Okay, well, welcome everyone. I'm Nancy Hoffman-Baniak. I'm CEO of the Greater San Fernando Valley Chamber of Commerce, and I'm joined today by my co-worker, Fumi Hashimoto, and our amazing presenter, Kim Guzman, the President and CEO of California Employers Association, who will be our presenter. We've known Kim for many, many years, and we've worked with them off and on. And since the pandemic, they've joined the chamber, and we're so happy that we have an amazing partnership. If you have received our poster sets, it is through our partnership through the California Employers Association that we're able to provide those to you, along with our sponsor, Russell Lookadoo at HR Architecture. So Kim is an experienced HR generalist. She's a dynamic speaker and a proven leader who's been successfully leading the California Employers Association since 2002. She's thoroughly immersed in the operations of it and all the human resources and the operations for over 25 years. And she's got experience in all different aspects of life. She exhibits her comprehensive bank of knowledge and crystal clear strategic guidance with her members and her staff every single day. We are very privileged to have her join us today, and I don't want to waste any more time. I want to get Kim going so that way you could hear what she has to say about all of the new laws that came into effect in 2023 and some of them that haven't been implemented yet but will be soon. So Kim, take it away.
Thank you very much, Nancy. Great to be here with everybody, the Greater San Fernando Valley Chamber. We love this partnership and we value this relationship. So we're going to spend about the next 45-50 minutes together. You are welcome to ask any questions in the chat box throughout. Nancy or Fumi will kind of interrupt me and let me know if you have questions as we're going. And the good news here is that there are not a ton of new mid-year laws. In California, it's not unusual that, in January, a whole slew of laws are passed, and then all of a sudden in April, there'll be a few more, and then in May, there'll be more, and then in July, there's more. And there are, and we're going to talk about those today, but not nearly as many as there have been in past years. So perhaps the governor is trying to give us still let us recover from 3 tough years of the pandemic. So we're here to help you be worry-free in 2023. And again, a little bit about who we are. We are a trade association, just like the Chamber. We're a 501c6, and our whole reason for being is to provide employers with peace of mind, specifically providing employers with peace of mind around employee issues. And so if you've got questions for us about, employee handbooks or onboarding somebody or letting somebody go, or you've got a pregnant employee and you don't know how to handle the leave of absence laws. Those are the type of things we handle all the time. We also do investigations, do a lot of great leadership training. And of course, we've been very busy the last 3 years with COVID. Thank goodness a lot of those are going away, and we'll talk about that in a few moments. But there's our information at the bottom of the page here if you want to get a hold of us after today's presentation, because there might be some things that I say that you're like, I don't get it, and I'd be happy to talk with you further about that. Now, our attorneys at CEA make sure we tell you I'm not an attorney, and I'm not giving you legal advice. And just like, if you met a dentist, but if he's not your dentist, he's not going to work on you, right? He's still a dentist. But we are not. We do have 3 lawyers here at CEA, but unless you've retained them, they're not your lawyers. So what we're giving you is a lot of great advice, but it's not a legal opinion. You'd have to go to your own attorney to get that legal opinion. So we're going to educate you, we're going to inform you, we're going to hopefully break down the law so that you understand. Sometimes they make laws so confusing, and really they usually start out not being confusing until a whole bunch of legislators get in and muck it up. So we try and give you, regular, real, everyday practical guidance and advice. So what we're going to hit on primarily today are these items here, which is one of the big changes that has happened for 2023 was pay transparency. So we'll start out with kind of refreshing you about some of the key things that you needed to be doing in January. And maybe in January, you either didn't know about it or you kept saying, I'll get around to it, and life has gotten busy and work has gotten busy. And you're like, I still haven't gotten around to it. So we'll let you know what you need to put at the top of your priority list. Cannabis in the workplace has been a big thing. Supposedly coming in January, which really is only another 6 months away, there's going to be some big laws around that, which we want to bring you up to speed on. CFRA had some changes this year. Want to make sure you know about those. And then we're going to talk a little bit about some things that be watching for there right now that are bills that are trying to get passed around paid sick leave and some other things. So should hopefully give you a nice, well-rounded view in the next 45 minutes or so. So as I mentioned, and again, feel free to use the chat box, and Nancy or Fayumi will interrupt me if you have a question, and I'll do my best to answer it. Pay transparency was probably the biggest thing that started in January. So this is not new, right? This has been in place for 6 months. However, as I look out there, I'm still seeing a lot of employers who are not doing this. And it's important because there are big fines of $10,000 and even jail time for not doing some of these things multiple times. So let's just do a quick review. All of us, if you had either 5 or more employees, we had to start providing a pay scale to any current employee when they request it. So if I'm just going to use an easy example of a receptionist. If my receptionist comes to me right now and says, Kim, I'm making $21 an hour, but I want to know what my pay scale is. I need to be prepared to tell her within a reasonable amount of time, which is usually less than 30 days, as far as judges are concerned. Well, you can earn between $18 an hour and $26 an hour in this pay scale. She needs to be able to know what the low end and the top end of her pay scale is. So that meant many of us, myself included, in January, we're like, oh crap, we had to go through all of our employees. We have 25 and take a look. What are they earning? What do we want the low point to be? What do we want the high point to be? Now, she can't ask me what other people are earning, and she can't ask me about any other pay scales. But if she applies for a new position within my company, she can ask about that pay scale. So that was kind of a new thing for a lot of us. Now, if you're in state or city government, that might have always been the case. But in most private sectors, that was not the case. The next thing is we had to start in January, and we just started then as well, just like you, maintaining records of job title and wage rate history for every employee. So that, let's say again, at the end of this year, I have an employee walk in the door and say, hey, Kim, I want to know how much I've earned over the last year, how many times I've had raises, how many different titles I've had. And again, this is the time to get on top of this now, because 3, 4, 5, 10 years from now, somebody might come to you and say, I want to know, I've been here with you 10 years. I need to know what wages I've had through that 10-year history.
So Kim, you have to go backwards in time too.
Well, you have to go backwards up to January 1. So January 1 is when all this started, January 1, 2023.
So if someone worked at your office for 10 years, you don't have to go back before January 1 of this year, just from this
Correct.
year forward.
Correct. Okay. Great question. Yes, this all started January 1. So it's not too late now, right? We only have to go back 6 months. That's not too hard to go back and recreate that. So you might want to have an Excel spreadsheet. You might have an HRIS system. We use Paylocity, and they have a system within Paylocity that will keep track of that for us. So, whatever system you use, if I walk into your door and say, hey, I just need to know, you need to tell me what my wage history and title has been. And if you have 15 or more employees, we do at CEA, then you have to also include the pay scale anytime you do a future job posting. So recently, we just had a job opening for a digital social media specialist. Doesn't that sound fancy? And we had to, when we put that job out there, we did it on Indeed and LinkedIn, and we did it on Craigslist, we did it on ZipRecruiter, we put it everywhere. And when we did, we had to put the pay scale that we were going to pay, not the pay range, but the actual pay scale, the low end and the high end. You can also include the pay range. You could say the pay scale for this position is $50,000 to $75,000, but the pay range we're looking to pay at this point is $60,000 to $75,000 or whatever. But you've got to include the pay scale for a position in any job. Even if you're hiring a recruiter to do this for you, they need to do it. So again, let me explain a little bit more. How do you define your pay scale? Yes, Nancy.
So someone has a question.
Sure.
For the rate range and title, can we have the minimum and the high end as open? Example, $18 an hour to open.
No, thank you. That's a great question. $18 is fine, but open is not working. No, because and here's the reason, if it helps. What was happening in the past? This is all about the California Pay Equity Act, and there was a lot of actual data that there was a big disparity between men and women, and also between different races. So, for example, maybe my husband would walk in and look at a position, and if you just say open, maybe you would have been willing to pay him $50,000, but I walk in and you're like, well, she's a woman, and she's probably married and has a double income. I can pay her 45. That was happening. There was a lot of actual examples, data, and accurate information about that happening. So this is part of Equal Pay Act in California. So there needs to be actual dollars, the low end and the high end. Now, you can certainly say it's going to be 50,000 to 75,000, depending on experience. That's true. That's fine. But you need to be then, what is the experience, and how are you going to decide that? And you need to look at your current employees. For example, I have 11 HR managers that are answering phone calls. We take 2,000 phone calls a month from employers just like you. And I've got 11 of them. And they're at different ages, they're different races. Some of them are bilingual, some of them are not bilingual, male, female. So how do I don't want to pay them all exactly the same, because they have different value. They've been with me different amounts of time. They have different experience before they came to CEA. And so I've got to come up with different levels that if you can do these things, you're at an HR manager 1. If you can do these things, you're HR manager 2. So I've got to kind of do what a lot of unions and a lot of state and city and counties do when they set up their pay structures. I need to have it written down so that it's not just Kim playing favorites and giving Mary 10 times more than she's giving Craig because she likes Mary and she doesn't like Craig.
Can you pay differential pay scale versus pay range?
Okay, well, differential pay scale is, can you pay a differential pay scale? I think the question might mean like if somebody's working swing shift or graveyard or weekends, and yes, you absolutely can.
He said you answered the question already. Never mind.
Okay, great, perfect. So this is just new for those of us in the private sector world to have to kind of come up with this. Now, again, one way to do it is to just go ahead and look at what is the lowest I'm willing to pay for this job, what is the most I'm willing to pay for this job, and have that in there. And then you can also expand it. So maybe right now I'm paying people for a HR manager role between 65 and 85. I can still say that it starts at 50 and it goes to 90, right? I don't want to cap people out and have people ask me, what's my top end? And I go, oh, you're at it. So you can expand your pay scale even though you're not paying anybody that highest amount. So here's kind of a quick little example. For each position, again, include the lowest pay and the highest pay. But then, so for example, let's say we have Eric and Hannah and Elizabeth, and they're all earning these 3 rates, 64,000, 72,000, 78,000. So then my pay scale should say that I'm paying 64,480 to 78,000. But I can expand it if I think I'm going to pay a newbie less, or maybe I'm not, maybe 64,480 because that's minimum wage, or the minimum rate you can pay somebody to be a salaried exec, by the way. So maybe I'm going to say the scale goes 64,480 to 90,000, even though I'm only paying people 64 to 78. So we have a great pay scale toolkit on our website. You need to be a member to access it, but our memberships are $99 a month, so they're inexpensive. But we do have toolkits. There's also other toolkits you could Google to find out, but don't let this scare you. At first it scared me, like this is going to be a ton of work, when actually I sat down with my controller and my other leadership team. It took us about an hour and a half. We just kind of went through, and you can change it. Okay, nothing's written in stone. So what I would say is, if I walk in the door and I say, I want to know what my scale is, and you say, okay, Kim, and you hand me a piece of paper, at the bottom of the piece of paper say, this is valid as of June 15th, 2023, and it might change. And in fact, it will change. So it's subject to change. So if you ever have to give somebody something in writing, I would put some little caveat that this is the pay scale today, but the company reserves the right to change this at any time for any reason. Because maybe Maybe pay is going to go down. Who knows? Hopefully not. The other thing, this is kind of, I'm going a little backwards right now, but back when I said, what is, if you have 15 or more employees, you need to do these job postings. That's 15 or more employees anywhere, okay? If you have just one person in California and everybody on your workforce is out of Boston or who knows where, or in another country even, doesn't matter. If you have 15 or more collective employees, even if only one's in California, these rules do apply to you. And they count for everybody, part-time, full-time, temporary, seasonal, exempt, non-exempt, it doesn't matter. So just remember that you've got to include the pay scale in your job postings, even with a recruiter. The pay scale has to be listed in the posting itself, and it applies to anything that could be filled here in California, even if it's going to be a remote job. Now, again, we've all been supposed to be doing this for the last 6 months, but if you haven't, this is the time to get on the ball, and here's why. Look at those consequences. $10,000 per violation from the labor commissioner. That's huge. I don't think any of them I have not heard of any being given out yet, but it's only been 6 months. But believe me, by the time it rolls over to 2024, if we're not complying, the labor commissioner, this is easy money for them, very easy money for them. So I would say get on the ball with this, make this a priority. No, it doesn't have to be perfect. And it's going to change. It's a living document, and call us if you have questions. We can help you. This is just a quick little sheet, again, help yourself. It looks like it's not as hard when it's colorful. So you would write down your job positions, you'd look at your job descriptions and make sure those are still accurate. And like me, maybe you start creating levels within a level. Maybe you have a salesperson, but you have a salesperson A, salesperson A+, salesperson B, salesperson B+, that kind of thing, because you might need to start delineating between several people or several roles within a role. You want to look at your payroll records. You want to create your own new pay scales and then review those annually and then audit them anytime you need to. You can change it. Again, it's a living document.
Kim, I got several questions in the chat.
Sure.
Does PAGA apply to the job posting requirement?
Yes.
And we'll talk about what PAGA is later if you don't know, because that's a whole webinar.
Yeah, that's a whole thing in itself.
If there was a job posting before January 1st of this year, would we still get a fine for not having that?
No, this is all as of January 1 this year.
What if you don't have a pay scale? What if the job just pays $18 an hour and the employer couldn't care less about your experience? That's just what the job pays.
Yeah, then that's what you would say. You'd say that I'd say, what is the pay scale? And you'd say it's $18 to $18. And I'd say, you're telling me I'll never get a raise? And you would say, that's right. This is a position that's only ever going to pay 18. So you'd need to find another position within the company or outside the company if you're looking for raises.
And then someone said you might have already covered this. Does this regulation apply to all employers or only those with 5 or more employees?
5 or more employees to have it, and then 15 or more. So if you have 5 or more employees, you have to do this internally to give it to somebody. If you have 15 or more, you have to have it in the job posting. So if you have 3 employees, you don't have to do anything. Correct.
I mean, you should. It's best practice. But
but by law, if you only have 4, 3, 2, and again, if you're the owner of the company, you don't count. If you own 10% or more of the company, you don't count as an employee, even though you may give yourself a paycheck and all that. You're technically, by law and by the labor commissioner, not considered an employee because you have ownership.
That's in the chat for now.
Great. So wrapping this up so we can move on. Again, the whole point is equal pay for substantially similar work. It's all about equity. I think that's a very good thing. Most laws honestly come out of trying to do the right thing. And there are those bad actors, those bad employers, and there's bad employees who don't do it the right way. And that's when these laws come about. If everybody just was their best self and did the right thing all the time, we wouldn't have all the laws we have. But unfortunately, with humanity, we're not that way, are we? So what about salary history? This is just a reminder, hopefully you already know this because this has been a few years, but you are no longer allowed to ask somebody about their salary history. And it's so bothersome. But it is the law, again, because they're afraid of bias and things like, again, what if they were willing to pay me $85,000? Then I walk in the door and they say, Kim, what were you earning in your last job? And I said, oh, 65. And then they go, oh, well, then I'll just pay her 66. So they do not, they being the legislature says you are no longer allowed to ask somebody who comes in for a job what their past salary history was. It shouldn't matter what they were making. The question is, what are you willing to pay? And so that's, again, part of the fairness. And I do understand that, even though it's frustrating when I interview people. I kind of want to know, what have you been used to earning? So what you can say, because there's always more than one way to skin a cat, is you can say, in this position, what are you hoping to earn? That's another way. So I'm not asking you what you used to earn. I'm asking you, what are you hoping to earn? What do you expect to earn? What do you need to earn in order to retain your employment with us? So I can ask those questions, during an interview, but nothing in the back, nothing going backwards. Again, keeping that Excel sheet or that HRIS system, that's a human resource information system, or your payroll records, something so you can start, if somebody walks into you 2 years from now and says, tell me about my pay history. Have you given me a raise? So you got to keep track of that with your payroll person. And then again, we have a pay scales toolkit if you need it. Are we ready to move on, Nancy, to talk about weed in the workplace? I hear no questions, so I'll assume we can keep on going.
Yeah. So, sorry, I was on mute. Yes, keep going.
No problem.
All right, hold on. One more question.
Okay.
What is response time allowance for internal pay history request?
Reasonable. And that tells you nothing. But what I have seen, what we recommend is anytime it says a reasonable amount of time, that is, what would a jury of 12 people think is a reasonable amount of time? We say always under 30 days. Okay. So maybe it's going to take you a week or two because you need to get your management team together and just say, hey, I promise I'll have that to you in the next 15 days, 20 days, but always within 30 when you hear the word reasonable. So you don't have to give it to them immediately. Thank you. That was a great question. I'll be happy to get back to you in 2 weeks. Is a very, very good response from you. Okie dokie. So let's talk about some weed in the workplace. Now, again, as a refresher, before we get into the new part of this, it was back in 2016, which I didn't realize till I did a little bit of work on this myself. It was back in 2016 that we legalized non-medical recreational cannabis. And that surprised me, like 7 years ago that was. And I think there's very few states that don't have this now. I think there's like 7 or 8 states that don't. Everybody else has at least recreational. And so that's how it starts out in a lot of states. Well, people can have it on their own. They can have their own plant. In fact, I was reading here, you're not allowed to have, when this law came out, you couldn't have more than 6 plants. And an average plant, just so you know, fun fact, the average marijuana plant will produce 5 ounces of usable marijuana. So if you had 6 of those plants, that's almost 2 pounds. That's a lot of marijuana. So anyway, that's how it started was, hey, if you're 21 or older, you can smoke, just do it at home. Don't do it out in public, don't grow more than 6 plants and so on and so forth. But as we all know, federally, it's still illegal. Even for medical purposes, it's illegal in some states. And so that's really getting pushed back in almost every state. People are pushing back and saying, hey, you know what? It's no worse than, a lot of people are saying it's no worse than alcohol. And you let me drink a 6-pack of beer on my own time on the weekends. Why can't I have a joint now and then on my weekends? How if I go to a party on Saturday, but I'm perfectly fine to work for you on Monday? Why do you care? The problem is, of course, is a lot of employers do drug testing. And if somebody gets injured and then they do drug testing, there's not a way to tell right now whether Kim smoked pot on the weekend or whether Kim is truly impaired this moment. You can tell that with a lot of other drugs, but with marijuana, it stays in your system for up to 3 weeks. So it's very hard to tell. Again, was Kim high on the job when she crashed the forklift into the wall? Or was she really high 2 weeks ago, and the fact that she crashed into the wall with a forklift today had nothing to do with weed, but it's still showing up in her system when I took her down for a drug test. So starting January 1, the new law is to say, hey, anybody who wants to use cannabis off-duty can, and employers cannot discriminate. If they see Kim out at a concert smoking weed on a weekend, they cannot take that into account in the workplace. If she's doing something off the job, just like drinking a martini, you're not going to fire her for that. You can't fire her for cannabis use. Now, what this is clearly also saying is it's just, again, I use alcohol because that's a great analogy. Kim can't drink a beer at work, right? Kim can't drink a car and drive. The same thing goes with cannabis. So in other words, Kim can't be smoking cannabis on her lunch break or right before she comes to work so that she's impaired at work. So it's going to be important for employers to be like, how do I know if somebody's impaired? Well, are they slurring? Are their eyes red? Are they not acting like themselves? Are they slow to react? There's all kinds of ways to try and determine if somebody is impaired, whether it's from alcohol or even like a Norco or Vicodin or something.
Okay, a couple questions in the chat, Kim.
Sure.
First of all, I think this one might go back to the pay scale. I'm not sure. If an employer does make the mistake of asking a question about past salary and interview, per the law, what action can the candidate take against the employer?
Okay, so just taking a quick step backwards, if you ask somebody about how much they were earning and they turn you into the labor commissioner for doing that, I don't know what the financial violation and offense is, but it would be heavy because you're basically discriminating. It'd be like asking them, are they married? Do they have children at home? How old are they? Asking somebody about their prior salary history is equivalent to that. It's illegal to ask that. So I can't tell you what the exact punishment would be, but if you didn't hire them after you asked them that question, they could absolutely sue you for discrimination and not following the law.
And then here's one with what we're doing right now. How about if an employer uses during their meal breaks, not on the premises, but they will come back to work?
Yeah, that would be a problem because, right, that means they're going to be impaired by the cannabis. It'd be like me leaving on my lunch hour and having a 6-pack of beer or even 2 beers and coming back. I'm going to be impaired. My judgment's going to be different than if I had not had any beer. And I don't care if you're tall or short, you drink all the time. The point is, during the workday, whatever your workday and times are, you're not to be drinking before or during those working hours so that you're not impaired while you are literally working on the job. Now, there are exceptions. Even when this starts in January, there's exceptions to the rule. If you're in the building and construction trade, this will not count because those are high risk and jobs with a lot of safety concerns. If you have a job that has anything to do with federal contract, federal background investigations, that this is not going to apply. It doesn't interfere with the DOT. So DOT, Department of Transportation, already has a very strict, and then they should, right? People are driving big rigs and things like that. They already have their own laws. This will not impact that. So this is going to be maybe more for like a lot of the white collar jobs, somebody working in retail, hospitality, things like that. That's where this cannabis law will come into play. And the question we get often is, well, will I still, once this happens, can I test people still? Like if Kim gets hurt at work, can I still test her for cannabis? And the answer is yes and no. Yes, you can test me, but the only thing you can test me for will be THC, which is the psychoactive drug that makes me feel high, be high, act high, but you can't test me for metabolites, which are the non-psychoactive part of cannabis. And that's what hangs on for 3 weeks, even though I have absolutely I'm not high. I don't feel like I'm high, but it's still in my bloodstream in my body. And that's a metabolite. So the big thing is, does Quest Diagnostics and all these other laboratories, do they have skilled, sophisticated lab technology to be able to handle this? And the answer is, we don't know. Not only me, but the laws are saying, you know what, we're getting a lot of pushback because a lot of these laboratories are saying we don't know how to pull apart the THC and the metabolites. So until they can get it together, they being the laboratories, and can tell the legislator, we have a, like these COVID tests, we can just do this little test and Kim's going to spit on it or pee on it or whatever, and that's going to just tell us whether she has active THC in her body or not. They can't pass this law. So there's a lot of talk in legislature about, is it going to happen in January? Is it not going to happen in January? And honestly, we aren't sure. So just be aware, it's coming down the pike. It's supposed to happen in January, but there's a very good chance it will be pushed back based upon the technology and the screening. Any questions at all about drugs in the workplace or marijuana or anything before we move on here?
So far, no. If anyone's going to
Okay.
say, chat, put it pretty quick. From now on, we're not going to go backwards to previous sections. We'll take those questions again later on. So if you have something from a previous section that you have a question on, make yourself a note and put it in the chat at the end.
Perfect. I like it. Okie dokie. So let's keep moving here. Let's, we'll talk about something new that happened this year that you might not have been aware of with CFRA, the California Family Rights Act. So CFRA basically, you might remember several years ago, the big deal was, whatever you do, don't hire 50 or more employees, because once you hit 50, all these leave laws take place. Well, what California's done is said, well, how come somebody working for a big company versus a small company doesn't still have all the rights? So they've changed it. So now they practically mirror everything, CFRA and FMLA, Family Medical Leave Act. So if you have 5 or more employees, it's the 5 rule again, right? You've got to provide up to 12 weeks of unpaid leave to somebody, unpaid, right? You're not having to give them a paycheck, but you do have to pay for their health benefits, and you have to hold their job and secure their job. It's really all about job security, keeping their benefits and giving them job security. And I'll show you here the reasons people can have it. But somebody to be eligible for CFRA with your company, the nice thing to know is they have to work for you at least for 1 year. Okay, so it's not like I start on day 1 and I get this. I have to work for you at least 1 year, and I have to have worked for you at least 1,250 hours in the prior 12 months. So that's really good news. But again, what I'm going to get is 12 weeks of time off if I meet these requirements. I'll show you on the next slide, within a 12-month period. And this is above and beyond pregnancy disability leave. So like if I come to you and you have 5 or more employees and I'm pregnant, I can have up to 88 days off. Again, you don't have to pay me. You just have to save my job and protect my job for me. You can hire somebody else temporarily, but when I'm done with those 4 months or 88 days, I get to come back and have my same job. And that's
Is that concurrent? Is that concurrent? Or
no, it runs separately. It's separately. So pregnancy disability leave, I could have 4 months, and then I could have baby bonding leave, and I could get another 12 weeks. So I could have 7 months off, protected leave, paid. I would get some payment from state disability insurance during the pregnancy leave. But yeah, it's not running concurrent. It's one on top of each other. So here's all the reasons I can come to you as your employee and ask you for 12 weeks off. Baby bonding, that can be an adoption, foster care. I have my own child. It can be because I have a serious health condition. In this case, not pregnancy, right? Because that's its own thing. We just talked about that. If I have a family member who just came home, maybe my husband's been in Iraq for 2 years and he's coming home and he's still on active duty, I can have time off to assimilate with him and to have our family bond together again. And if I have a family member who's got a really serious condition, somebody in my family has a heart attack or open heart surgery, cancer, whatever, I can have time off to take care of them. Again, you're not paying me, you're just holding my job and giving me benefits. So what's new about this? Because this has been around for a couple of years now, but what's new this year, if you didn't hear about it in January, you're hearing about it today, better late than never, is there's now a designated person. So whereas it used to be, I've got to take off time to care for a family member, and that's in the law. It kind of says husband, wife, grandparent, child. It gives you a list of whose family. Well, today's families look very different, right? There might be an aunt raising, there might be a next door neighbor raising a child. It might not be so now employees can take off mandatory paid sick leave and or they can take off time for Family Rights Act. So if your employee says, hey, I got a week of sick leave, I want to take it off and I want to use it to care for a designated person. And a designated person is basically anybody I want to designate that I think is somebody who's like my family. And, you know, the person can designate the person at the time of the request, and you can limit it to one designation per year. But the big takeaway here is, in my opinion, is you don't really need to be the person who says, well, I don't think your aunt is really a part of your family, or I don't think your neighbor is a part of your family, or I don't think your husband's cousin is really your blood relative. Why are you taking care of your husband's cousin? Or maybe this is you're a female and you have a female wife, and maybe you as the employer aren't really a fan of the LGBT community, and you may in the past have said, well, she's not really your family. You can't do that stuff anymore. So again, this is all about equality and giving everybody the same rights, whether you're in a traditional family setting of a husband and wife and 2 children, or there are all the other myriads of types of families that are out there that are equally important. And so it's about keeping families together and giving people time off to help out people in their family, and maybe their family is a friend. So designated person now is a new term instead of just a family member. So that's a big deal. The other big deal is bereavement leave. Now, I don't know about you, a lot of employers, you have policies where you do or don't let people have time off to, you know, and maybe you do or don't pay your people if they have somebody in their family die. Well, starting in January, 6 months ago, just a reminder, the new law came out, Assembly Bill 1949, for bereavement leave, which said if you've got 5 or more employees, you have to give your employees 5 days of unpaid. Again, you're not having to pay it, but you need to let them go where they need to go to fly for a family funeral or whatever when the covered family member dies. So, and again, let me look at the covered family members. It's on the next page here. We'll show you who the covered family members are. So here's the eligibility requirements on this one. 30 days before they leave. So I could start working for you on May 1st, right? And on May 31st, I say, guess what? My grandmother died and I need to take time off and you need to hold my job for 5 days, and you'd have to. Now, the other things that we need to know is that employees have to use their time off within 3 months. So maybe I say, guess what? My mother-in-law died. I need 3 days now because we're flying to Michigan for the funeral. And then, you know what? I'm going to need 2 more days later because I got to help my husband with all the paperwork. We got to go back and sell a house, you know, whatever. So it doesn't have to be 5 days consistently in a row, right? Doesn't have to be consecutive time. You as the employer can, and I say you should, request appropriate documentation, because you don't want me to have, you don't want me to have my same grandmother die 5 times in the same year. So you can absolutely say, Kim, I need a birth certificate. Excuse me, I'm sorry, a death certificate. I need a celebration of life pamphlet. I need something out of the obituary. I need something to tell me that this person really did die. And you want to ask that of everybody, right? Across the board all the time. And I can ask again and again. So it's not just one and done. Every time I have somebody pass away, you need to hold that time for me. Again, it is unpaid. You can say, Kim, use your vacation time if you want to get paid. Use your sick leave if you want to get paid. So you want to change your policies to make sure that you talk about this bereavement leave. You've never out now, if you already offer better than this, great. This is just the minimum of what the law is requiring. And I mentioned to you that I would tell you who the covered family members are. And covered family members are your spouse or domestic partner, your children, your parents, your parent-in-law, your siblings, your grandparents, and grandchildren. And that's who is covered by this. So it's not anybody and everybody. It's limited here.
So Kim,
But again, the leave is per death, not per year. Yes, Nancy.
Okay, and you may have touched on this. Can someone take off time to care for family member, CFRA and FMLA that runs concurrently?
It's rare that CFRA and FMLA are almost identical. So I'd have to hear your particular situation because they both really allow the same amount of time. So it's pretty rare that you would have somebody doing 12 weeks and then 12 weeks again, especially if they're not a pregnancy situation. because CFRA takes the place of FMLA in almost every case.
Okay, and then if we currently have a paid bereavement leave, do we have to provide an additional 5 days?
No, again, this is the minimum of what the law allows. So if yours is better, if you give people 5 days paid, well, then that's even better. If you give somebody 2 weeks, that's even better. This is the minimum of what you have to do. You can always do better than what the law is requiring you to do.
Okay, then our bereavement leave is 3 paid days and 2 days unpaid. Is that?
That would work. That would work because they're asking for 5 days unpaid. You're giving 5 days, 3 paid and 2 unpaid. So you're doing better than the law allows. But you want to check your policy. Are you making sure you say they don't have to use it consecutively? Because that's something that might be new that you need to add. And the other thing is on this one, you can require an eligibility of at least 30 days of employment. If you don't already have that, you might want to add that. And then again, here they're saying you have to use all that 5-day time within 3 months. So if you don't already have that in your policy, this might just help you tighten up your policy.
Okay, that's in all for now.
Perfect. Good questions. So again, just take a look at your policies and your forms. Make sure your paid sick leave talks about that designated person. Make sure your CFRA now says the word designated person. Make sure your bereavement leave policy is updated. If you have forms that you hand out to somebody, make sure those things are changed and updated. Make sure you have a 2023 labor law poster, right, that Nancy talked about that you bought from them.
And if you don't have one, we have them available.
Very good. Go buy one. It's pretty darn nice and easy, cheap, $20 or whatever you're charging. I don't know what you're charging.
Femi, can you put the link in the chat?
Yep, I'm on it. Yep, I'm on it.
Okay. And then there's a little bit.ly down here if you want to link on that if you have questions about the posters. Those are our posters, which we sell to Nancy to sell to you, but we give you guys a great deal. We honestly do. So much cheaper than going out and getting them anywhere else. All right, so we're ready to move on here. And I know I'm going to be paying attention to time here. I know we're at 10:44. So COVID. I mean, we're all tired of it, but it's still happening. The nice thing is it's a lot better as far as, we'll show you here in a minute. It's like, instead it used to be 10 days, now it's only 5 days of isolation, thank gosh. Basically, Cal-OSHA had to set aside some permanent COVID standards, and that's from February 2023, and that's going to go through 2025. So some requirements are even hanging on until 2026. So that's kind of interesting because that tells us how long we think this is going to continue to be around and continuing to be a problem, is all the way another couple of years. Most of the emergency temporary standards are the same. The biggest change I will really say is that there was a time where we had to do daily screening and we had to have exclusion pay, meaning if somebody got sick at work and then they had to take time off work and they knew they got sick at work, we had to give them exclusion pay. All that is gone. If you want to just make sure you're up to speed, I would encourage you to download this employer fact sheet we have here. Just type in that bit.ly/dir_COVID_regs, and that will give you all you need about what's going on right now with COVID. The big news, as I mentioned, is if you have somebody now who says, I'm positive for COVID, they only need 5 days in isolation. It doesn't have to be 10 days away from work. As long as they come back and they're feeling better and they've been fever-free for 24 hours, you don't have to ask for a negative test. Hallelujah. So much, much easier. So Joe calls you on Monday and says, hey, I got COVID. And you say, okay, 5 days till you can come back. If you're feeling good, you can come back on day 5. And again, you're not going to pay him for that unpaid time. There used to be some vaccine requirements. Those are gone now.
Well, and this is for Kim. It doesn't matter what size business you have.
Correct. Any size employer. Great. Yes, good question. You may have noticed as you walk into hospitals, you don't even have to wear masks anymore. They're in most cases, they are optional now, which is awesome. Okay, I'm going to switch off of COVID, thank goodness, unless there's a COVID question. We're switching to some new stuff. This is going to be decided in August. But the big deal here is we've had outdoor heat illness prevention policy standards for a long time. There was so many horrible stories of people working in horrible heat outdoors all over the country and dying because they weren't given water, they weren't given shade, that kind of thing, especially for working on farms and things like that. Construction, anything where you're just outside all the time. Imagine what the temperature is standing on asphalt when it's 110 outside and you're standing on asphalt all day. So they came up with heat illness standards years and years ago that said if it was a more than 82 degrees, you had to give people water and water stations and breaks and shade and all these things. And so that was great. Well, now, there's been a lot of injuries and illnesses due to heat indoors also. So now the new draft regulations that are out there and are going to be going out for public vote in August is what about indoors? And that would mean that anytime it was 87 degrees, you'd have to start some of the same things you start outside at 82 degrees. So a cool down time, a cool down area, break, more break, that kind of thing. So stay tuned that if you are indoor, but you have a hot indoor, my girlfriend works at a gymnasium, like a fitness gym, where little kids are doing tumbling. And they don't have anything except a swamp cooler. And it will be 110 degrees in there in the summer. And it's just brutal. So they will have to make some new accommodations for their employees where they haven't in the past, just to stay with these regulations. So stay tuned. All right. The other big change, of course, that happened and is happening all over here, and I'll show you a slide on the next one about where it's happening in July, but is minimum wage increases. So January 1, the whole state of California finally went to one flat rate, which was $15.50 an hour. It's like, hallelujah. It's not this, you have more than 26 employees, you have less than 25, blah. It was just, we don't care if you got employees, it's minimum wage is $15.50 an hour. But then there are about 40 cities and municipalities that said, that's not really enough of a living wage for San Diego or Emeryville or San Francisco or wherever, or LA. So those cities went above and beyond and kind of trumped, if you will, the minimum wage laws. And that's happening again in July. So the state is remaining the same, but in all of these locations, it's going up in July. And it already went up in San Mateo County back in April, which was kind of weird and out of the ordinary. Again, I'll show you that slide again, but just so you know, the local minimum wage is based on where the employee is physically working. So if you have me and I'm working for you in Sacramento, you can follow Sacramento, which might be better for you, right, as the employer. But if I'm living and working remote and I'm in San Diego for you, even if you're in Glendale or wherever, it doesn't matter because it's wherever I'm physically as the employee working. Where am I going into the office every day? If it's in my house, you use that minimum wage. If it's in your office, you use that location. And again, it's $15.50 an hour, except in all these places it just increased, and in many places it's a lot higher. So there are 40 different places where it's higher than $15.50. You can find a full list down here on this bit.ly below.
Doesn't that kind of defeat the whole purpose? If I live in the city of Santa Clarita, and I'm at home today. Let's say I was working home, and Fumi lives in the city of LA, and she's working from home. So her minimum wage is $16.78, and my minimum wage is $16.90. Like that's, and then all of a sudden, let's say I move back to the city of LA, then you're able to drop my wage.
Yep.
Okay, and then let me ask them this. So now you're an employer and you have employees working in another state. Where does that fall into all this?
You have to follow the laws in that state. And I recently had that. I had a marketing person and she lived in Boston, Massachusetts. And I thought, well, that has to be better than California. No, shockingly, it wasn't. And so I had to pull down all the wage and hour laws for Massachusetts. And it was weird things like you can't work on a Sunday. And if you do, you have to get paid double time. So I had to follow those laws, which were shockingly even worse than the laws in California, or worse might not be the right word, but more employee friendly in Massachusetts than they are in California. So you need to follow the laws of where the person is working. And so it is important to keep track of where your employees are, because you'd be surprised how many employers don't know that their employees have moved because of COVID, and now they're in another county.
Yeah, I mean, I know people who moved to another state and didn't tell their employers as they were working remotely.
Yeah, and that could run into some problems later on down the road.
So with that, what's your advice for a workforce that goes to a customer location across jurisdictions, like a plumber?
That's a great question, Nancy. So anytime one of your employees, like work at plumber, tow truck company, whatever, Amazon delivery driver, I don't know, you've got to be, if anybody is in a particular city for 2 hours or more than 2 hours, so the minute it hits 2 hours or more, you have to pay that rate. So what you'd want to do is, if you had a delivery driver or whatever that went to these 3 cities every day or these 7 cities every day, you'd want to look at all those cities and you'd want to say, what's the highest of all those? And then just pay that is what would be the easiest. Otherwise, you literally have them log, I was 2 hours in Oakdale, I was 2 hours in Berkeley, I was 2 hours in Alameda or down your neck of the woods, you know, I was in Glendale, then I was in Pasadena, then I was in LA, then I went over to San Diego, then I was in Orange County. So what I do is, for mine, is I just look at who do I have everywhere across the state or even out of the state, and I try and pick that highest wage and just make it clean for everybody.
I know that's what a lot of our members do, that they look at the highest one if they have drivers. FEMA just put in the link, the city of LA's minimum wage, because it's different than the states. Make sure, even if you have a labor law poster and you're in the city of LA, you print this and you stick it next to your labor law poster. And she's going to post the county too, because you could be in either an unincorporated area, or you could be in a city that doesn't have its own minimum wage, but you're in LA County, like the city of Calabasas or Burbank. And so if you're in one of those cities that do not have their own minimum wage, you have to follow the county's minimum wage. And so you'll have to put that poster up. I know a lot of businesses that put both posters up just to be safe.
Yep. Yeah.
Unless they absolutely know they're not in the city of LA. But if you're in the city of LA, it doesn't hurt you to put the county of LA. You just have to follow the city.
I like it. I like it because you guys know what you're talking about. You'd be surprised how many places I give this to and they don't really understand. You guys are already dialed in on so many of these laws. I appreciate that. So you may have heard, because you are that far away from Los Angeles, that there's a lot of predictability pay things happening. So more and more cities are starting to adopt what they call fair workweek ordinances.
Kim, we're part of the city of Los Angeles. We are the city of Los Angeles.
You are part of this. When you say we, you mean?
The San Fernando Valley predominantly is the city of Los Angeles.
Okay.
It has 5 cities though, but 90% of it is the city of LA.
Okay. Okay.
The rest of them are individual cities that do not have their own minimum wage. And West Hollywood is the highest in the state right now at 1908. So they're in the county of Los Angeles. But Russell, they have their own minimum wage posters for that city. So we are, like when you say Los Angeles, people think we're Van Nuys or North Hollywood. That's all the city of Los Angeles.
Okay.
Those are just communities.
Most likely, almost all of your members should be adopting fair workweek ordinances, which basically just says, hey, I'm going to let people know their schedules in advance, and I'm going to let them know when I need to change their schedules. Now, again, hospitality, restaurants, retail, you know, I remember I worked in retail for years. I also worked in restaurants, and it would be like, I need you to come in today. Or, you know what, never mind, I don't need you to come in today. When I've already got a babysitter, I'm in the car, and now you tell me you don't need me, and I've got paid for a babysitter, that kind of thing. That's the whole point behind this law, is be good to your employees. Don't be switching their shifts around. You know what? It's the cost of doing business if you're running a business that has those shifts and those demands that go up and down, but it's not your employees' problem to have to deal with those. That's unfortunately for you, the employer, that's your decision to try and figure out your scheduling. But you need to be looking, if you're not certain about this, look up predictability pay, look up fair workweek ordinances for Los Angeles, and make sure if you are in there that you're doing that scheduling appropriately, so that one of your employees doesn't file a labor commissioner charge against you. Remote I-9, I'm trying to rush now because I know we only have about 5 minutes left. Real quick, there were some flexibilities. During COVID, if you were 100% remote, then you didn't have to ask for, the I-9 form, immigration form. You didn't have to ask to see somebody's identification, their passport, their social security card, their driver's license. You didn't have to ask to see that in person because it was remote. That's over, that's gone. That expires July 31st. And what that means is you've now got 30 days to go back to anybody you hired between March 2021 and July 31st, 2023, that you didn't actually physically see their stuff, that you've got to get that. So you can either have them send you something, you can have them come into the office and take a picture of it. You don't have to get a picture, but you have to physically verify that you saw the documents. You can hire somebody else to do that. You can have them go to a local lawyer. You can have them go to a notary public, whatever. But you as the employer do need to physically examine documents and go back now and update all those I-9 forms. So I would advise you to talk to your legal counsel about the best way to go about that if you have a lot of employees, and especially what if they're in Boston? You going to fly them over here, or are you going to hire somebody in Boston to go take a look at it?
So Kim, if
Yes.
the I-9, if you saw the documentation via a secured link, do you still need to have the person bring it in?
Well, all I can tell you is what it says here is if you were looking at it remotely and you were not physically seeing it with the whites of your eyes, like a Zoom thing wouldn't work. You have to be able to physically examine it and go, does this look fake? Does this not look fake?
Well, I'm saying that, but she's saying like they scanned it and uploaded it to a secure link.
Nope, that would not count.
Okay.
That would not count. You could fake that very easily.
Okay.
So, yeah, so you want to maybe talk to your attorney about the best way to go about doing that, or you can call our hotline, our 800 number, and we can help walk you through how to do that. And again, you run the risk of it. Maybe you get an I-9 audit, especially if you have a large workforce. If you have a very small workforce, maybe you're like, hey, I'm willing to take the risk. It's up to you. I'm not the police. I'm just the messenger here. But if you have a large workforce, it's worth going back and doing that right. And speaking of I-9 forms, there's a new I-9 form coming out. Supposedly, it was supposed to come out on March 31st. I still have not seen the new one. I don't think it still is out yet, but the new I-9 form will talk about gender identity on it. So instead of saying, am I male or female, it's going to allow people to individually self-identify and maybe say, I don't believe I am male or female. So that's going to be something new. So you'll be seeing those coming down, supposed to be released later on. Again, as you can see, it was initially talked about in October, then again in March. I still have not seen the new one come out yet. Briefly, looking ahead here, just we don't know, layoffs are happening. You've heard about them, particularly in the technology industry. My daughter worked for Verbo, then she went to a startup off of Verbo. She just got laid off. She's in Austin. There's a lot of layoffs going on in the technology world. Unemployment is really flat with 2022. So, I mean, you listen to the same things I do. I don't think any of us know, is inflation going up? Is it flat now? Are we going to have any more rate increases? Overall, they say there's a population shrink out of California. Will that continue? We don't know. I'm looking for a house right now, and I can tell you those house rates have not fallen a bit regardless. So it's really confusing out there. What's interesting, though, is remote work is here to stay. You've heard about a lot of companies bringing their remote workers back, and those remote workers are ticked off and quitting in droves. A recent Pew study said that with workers, there's 1,000 workers that had a job that could be done remotely. 35% of those do it. So in other words, if you can work remote, if your boss gives you the option, with the people that were surveyed, about 35% of them said, I want to work 100% remote. Another 41% said, I'm working a hybrid schedule. And again, I'm sorry that we're rushing here. Chat GPT, Nancy and Fiumi are working on an talking more in the future with some newsletters, and maybe we'll do another webinar about ChatGPT. Why should you care? Because it only took 5 days for 1 million people to use OpenAI ChatGPT, and it took 3.5 years for 1 million people to use Netflix. That's why you need to care. ChatGPT, other AI, it's here to stay. It is, I will tell you right now, my personal experiences with OpenAI, ChatGPT, it's a game changer in a good way. It's helping me enhance my workforce. I haven't laid anybody off because of it. It's making all our lives easier. We have personal assistants now through AI that we didn't have before. But ChatGPT, you will continue to hear more and more. And I know Nancy said she'll bring me back to talk with you more about that. The biggest thing I do want to leave you with, though, on that note is you need to start thinking about what you're going to do in your workplace. You need to think about policies. Are you going to let your people use ChatGPT at work to help with job descriptions or help with newsletter articles or blogs or customer service or chat bots? Or are you not going to allow them? You need to make some decisions and you need to do some more research. I'm happy to talk with you about what we're doing at CEA, but you need to have policies and procedures around ChatGPT and other AI, artificial intelligence. I do believe ChatGPT is kind of like starter dough. I think it's a great thing, especially if when I got writer's block. It's not the be all end all. It doesn't take the place of me or my marketing team, but it helps us all. So that's my personal thought on it. And we are at 11:03. I'm so sorry. Real quickly.
It's okay.
Okay, good. So sick leave, there's a bill right now, Senate Bill 616, that says, hey, there's legislators that want to expand sick leave from 3 days, which it is now, right? Required paid sick leave right now today in California, minimum 3 days, wanting to expand it to 7. Ouch. There's also a family caregiver as a new protected class so that you can't fire somebody because they're a family caregiver and they keep missing work. It'd be like protected class like marriage status and race and religion and all that. Family caregiver would be a new protected class. So that's in the works. Who knows? These may or may not pass. And then look at this, healthcare. They're looking at making a minimum wage in California for any healthcare related jobs starting at $25 an hour. You can look at all of these and do some research on your own if you want to look and see where they're at or what they mean.
Or you could join our government affairs committee and you can hear about all of them.
There you go. I like it. I should join that committee, Nancy. And then also workplace violence. Cal-OSHA is getting much more in the act, all the active shooter things happening. So they're working right now. I haven't seen any final drafts, but looking to impose some requirements that we all should have certain workplace violence regulations and policies and procedures. So the healthcare industry right now is the only one that has specific requirements, but Cal-OSHA is saying, hey, it's coming down the pike. And literally, as I end today, and take a breath, what I just want to say overall, what we try and help you do, because the fact that you're on here tells me you're a good employer. You care. You want to stay up to date. You want to stay out of court. You want to do the right thing. You want to know what the laws are, even if you don't always agree with them. You need to follow them, right? We need to do that. With everything that we share, it's all about how do we keep it about us and humanity. I talked about that at the very beginning. If everybody did the right thing all the time, we wouldn't need to remind each other to keep humanity in the workplace. But it's been a long 3 years. It's been tough on you, the employer. It's been tough on your employees in different ways. So my biggest takeaway is do what you can do. Call us if you need help. Doesn't have to cost you, to have really cool things in place to keep your good people there. It's not all about the money. That's what my employees tell me. Honestly, it really isn't now more than ever. Are you giving me flexibility, Kim? Are you giving me time off when I need it? Are you celebrating me? Are you valuing me? Are you just giving me grace if I'm late to a Zoom meeting or whatever? Are you recognizing me? But happy people are productive people. So what are you doing to keep your people happy and really just doing everything you can to thank your people? Talk with your management team. I know sometimes I go to bed, I'm like, I'm exhausted. I don't have time to thank my whole management team too, but we all need it. We all need thank you and celebrations that don't have to cost a lot of money, but that recognize people, because all those things will help you keep your good people, get more productivity and engagement out of them, help with profits, right? Help with better customer service. Usually that reduces any injuries and illnesses because it's a better workplace. But I know we covered a lot here today. Here's the highlights of what you need to do, and in addition to just doing your best to keep that humanity in your workplace. If you need any help above and beyond what I've given you today, again, we have a $99 a month, this here associate membership. We can help you, give you answers all year long.